Yeah.
So what are the current challenges about the traditional litigation practice and traditional way of arguing cases in the court of law and judicial process?
Yeah, the challenges of traditional practice uh, in the times of COVID and before and after, you can look at it that way. The challenges are the numbers, obviously. We are talking about litigation pendency of somewhere close to about 32.4 millions. Probably the one other country which has more numbers is Brazil, a larger population, larger size, not the population. And it is there available in the national judicial records of the grid which provides that, the judicial decisions of how they are taking place, how many cases are getting instituted. It lets you know out of about this 30.4 million cases, you have somewhere close to 9.05 cases are civil and 23.39 million cases are criminal. So therefore, the large pendency of criminal cases is a major issue. The challenge, therefore, is the large number, the huge pendency. So the lawyers, the judges, and the system which runs them, all of them have to be performing at its optimal, the best level. Whether they're doing, they surely are not. If they're doing well enough, you won't have this kind of accumulation of numbers, will you? So therefore, the big challenge for any person is handling these numbers and devising strategies for coping with these huge volume of cases. We need, therefore, an intelligent bar who is a responsible bar, which will bring into the stream only those cases which would require keen adjudication, requiring a judge's intervention. And we require judges who work hard, who are able to devote time to deliver quick justice, not lengthy ones, quick justice, and where all the rules of the game are properly done with appropriate opportunities for parties to be representing. Improving the access to justice itself is a constitutional goal of what the directive principles of state policy also thinks about. So how much we can keep the gates open for persons to participate in the court system and then have their cases decided quickly. The access to justice, when we are saying providing lawyers and making them possible to come, it just is not the answer. We'll have to access to justice is intimately connected to our ability to dispose of as quickly as possible. Therefore, that is a major challenge. We are still adopting several archaic methods of dispute resolution. Everything goes to the conventional court system, and it takes a long time. A case with no restriction of time about the arguments. You can argue at any length of time, and the trial takes a long time. The witnesses are not immediately available. A couple of days back, when the Honorable Judge, Justice Chandrachud, was addressing some students in some part of India, he was making reference to about the major cause for delays is seen as the inability to serve. Service, many cases get the language at that stage. So therefore, such a simple thing as service of notices is a big deal for us. So therefore, there are areas where probably lawyers do not have immediately an answer, but then our methods of communication, which are improved to communicate them in so many ways, telephone and things, we will probably devise methods which are different from merely service of notice through amines and bailiffs. So therefore, that is a challenge. So I would see at every level, there are systemic challenges which pose huge burden on the judiciary's ability to dispose of them quickly. There are issues of quantity and quality about our judges' appointments. They don't immediately come. There is invariably some large backlog of vacancies which do not require, which require immediate attention, but which do not get that kind of attention which they deserve. And good quality of lawyers. It's again a very important thing that law schools must turn out good students who are prepared to put their best efforts. So therefore, that's also a very important thing. The Bar Council of India, which is responsible also for improving the standards of education, legal education, they must put their heads down to see that they turn out good students with passion for law, passion for litigation practice. When we're talking about conventional court systems, we're talking about litigation practice. Now, so much is connected along with courts these days, which will also be considered as we go along. So I see that challenges are immense in every sector of what we are talking about. So this is how I see the picture about the challenges.
Thank you, sir. How the coronavirus pandemic, the COVID-19, has affected the advocacy and judicial process?
How has it affected the judicial process? Simple thing is, when we're talking about access to courts, that is the way we perform best. The optimal performance of courts is making the lawyers, litigants, every one of them to arrive in the courts and have their judgments taken, the trial to be proceeded. All that has got seriously affected. Courts are a big no-no. Any public place is a big no-no. You can't go to those places. But then, thankfully, the Supreme Court has intervened at the right time, and they've given permission at all levels to have courts. Every high court now is having important cases listed. They have their own protocols given out, and the e-filing is taking place almost in all states, and therefore the major problem which is taking place of a person's inability to travel, arrive at the courts, is now handled in some way by making possible persons to file their cases through a digital format. But it's not a regular courts. Again, when we're talking about the hearing of cases, today I see in the Supreme Court as well, all judges now, they are in 15 in benches of 2. There are about probably the judges work and kind of a roster which is prepared by the Supreme Court. The high courts, many courts, they have cancelled their so-called holidays, even if there are summer holidays, they are working right through, and they are taking up urgent cases which require immediate intervention. And the criminal cases, it's again of bail. And there are areas of still some conflict, there are some problems of whether the police could be directed to give the charge sheet within the time which is prescribed by the Criminal Procedure Code. And there is a mandatory bail which is available there under the provisions of the CRPC if the police investigation is not completed and the charge sheet is not prepared, in which case they are entitled to. Even there are differing views of if the Supreme Court was providing for a kind of a reprieve and extended the period of limitation, and will that also extend the period for the police to give the charge sheet, was a question. And I see that in the Madurai bench, there are 2 differing views which have come through. Or one judge saying that this does not allow any benefit for the police to take extended time. And another judge saying, now that will be a dangerous thing. The investigation has to go, but if they are also prevented, if the police presence is necessary elsewhere and they are there in the duty for health care, how can they be forced to be sitting there in the police station to prepare charge sheet, carry out investigation and do that? So there are different views. And therefore, while many courts have let off and given reprieve to persons even without applications, they have ensured that under trial prisoners are not unnecessarily being held back, except in very heinous offences. I think many of them have had the benefit of bail. So therefore, the challenges due to COVID-19 is a kind of a fetter which has happened to the access to the courts. But we have done reasonably well, but I will not say it's all very good, that e-filing is taking place. It is not as if it was because of COVID, this has happened. It was already prevalent in some courts. There were some paperless courts in Delhi High Court. several judges where in that court, you don't need to present any physical documents. It was possible for you to have all documents in digital format. But now it is becoming slowly a norm during this time. But I need to again take that expression of what Justice Chandrachud was saying there before yesterday, that virtual courts cannot really displace the actual courts. They just can't. So therefore, in whatever way we have been trying to cope with, it's minimal, considering the kind of numbers which I was telling you, when we were talking about 32.4 million cases, or what we are able to dispose of through this phase, through virtual courts, is very minimal. So therefore, it has affected in a big way. There is no question. And that's how I see. And we have done reasonably well with the given infrastructure. We have done rather well to take up at least immediate cases, both in civil and criminal. In criminal, we are talking about persons who are held back without trial, and they must be immediately discharged. And that has happened in a big way. Same way in civil matters where interim orders are necessary. All courts are allowing for e-filing to take place and interim orders to be given by judges sitting in the courts and in the chambers, probably with computer connectivities, and they're able to pass orders. This is how I see in this situation now.
Thank you, sir. It is said that justice delayed is justice denied. We have already millions of cases pending in various courts in the country. The corona pandemic has further raised the piling up of the cases. How the virtual court system and use of artificial intelligence can help us in improving the situation?
We have to come with new ideas. We cannot. It was probably in a Pound conference, the early part of the century, last century, when Professor Pound, and that was in 1907, he said that there is something seriously amiss in the administration of justice. Many people are very unhappy. What are we going to be doing about it? So therefore, he was prepared to take the question head on and say, now, all is not well. What are we going to do? And this engaged the attention of a lot of people. And there were academicians were writing articles, they were engaging in discussions. Courts were talking about it. And this was again taken up later in the year 1976, when the Chief Justice of the US at that time, Chief Justice Berger, he collaborated with some persons, particularly a Harvard professor, Sanders was there. They were talking about a multi-court door system, where the courts open with several doors. What will that be? The courts will just not be merely listening to cases in courts which are coming to them, conduct trials. It should have mediation. It should have arbitration. It should have judges the formulation of settlements. So therefore, a court system will just not be a court adjudicatory mechanism with the judge sitting there in the pulpit and the lawyers arguing, disposing of cases. There are so many other things which have to be taken. And this was widely accepted across the world, and India also came through this. And if I see the number, because you are talking about the huge dependency and what are we going to do about it? I already said as to how the serious challenges exist at every level, from the lawyer's point of view, from the judge's point of view, from the systemic way we approach justice. Now, therefore, we have very clear understanding that we need to be opening up in several ways. We need several ADR formulations are necessary. And you are also talking about how these virtual courts and artificial intelligence will impact. I can tell you that there are some inherent limitations of virtual courts. We need to know that they're unique in their own way, because a process of a real court hearing is very hard to replicate. Such as, have you ever seen, many of the students must have gone to the court and seen, when an argument is made, there'll be a junior instructing the senior, he'll pick up some papers and then hand it over to the judge just across the table. Now, handing over things like that, transmission of documents and evidence or what you have immediately to be transmitted to the court, it just doesn't take place. It requires enormous preparation, sufficient anticipation of what could come, so that everything is ready at your hand digitize them all and make them available to the court. Supposing the judge asks a question and you need to have something, you have evidence in your hand, you did not anticipate that question and therefore that evidence was not given, you'll have to transfer it. So therefore, there are problems about the transmission of evidence and documents in digital format. That's one thing unique about virtual courts. And there is a problem. Now, recently, there is a report which has been given by Vidhi, is a policy study they make, youngsters who are doing a great job. And they pointed out to this, there is a lack of consistency. The systems which are operating in various courts, probably you have the formulations on Ubuntu platform and all the coding has been done. But what should be taken? What should be the medium in which you hold the courts? Is it Zoom? Is it Team? Or is that an exclusive thing? What are the issues of confidentiality there? There are big things. So therefore, consistency and standardization of what is lacking there was even admitted by the E-Committee, E-Court chairman day before yesterday. And so therefore, that's a major drawback. And there is no dedicated staff. You have the same staff. I had an experience a couple of days back when I was trying to advise a lawyer here for filing of some case. And he was preparing everything and trying to send it. You sent it through email. And there was a phone call from the other side. You have a large document, all of them compressed and set in a zip file. And that person there is receiving it in his cell phone, and he's not able to unzip the files. I was surprised that you have a staff who has to see first, initially to see, before he puts it to a clerk, before the work gets assigned. You don't have enough facility for that person to even do it. He is doing other kind of work. So therefore, for that person who is under normal times doing other work, as also to handle the virtual courts, could be a difficult thing. He needs to have appropriate infrastructure, appropriate equipments and gadgets to download documents, to immediately take copies of documents and then give it to the judge in a format which is acceptable. So all these are issues. We don't have lack of appropriate staff, and there is not even a full-fledged legislation for virtual courts. And these are all procedural matters. You don't have anything clear. Though you have an Information Technology Act, digital format Evidence Act has also been amended. Therefore, digital evidence is possible for you to introduce. But then the manner of institution of cases, the statement to be given, the trial of how it takes place, all of them are what you find in the Civil Procedure Code or the Criminal Procedure Code. They were all drafted at times when we didn't have all this technological know-how to speed up things and the virtual courts. So therefore, there is an urgent need for making an exclusive legislation for this, or incorporate appropriate provisions there in the CPC itself. So therefore, these are the true limitations. And you were talking about also about what this artificial intelligence can do. Probably that's an interesting field. Now there has been some attempt for the court, for the Supreme Court to recommend, after constituting a committee, the areas of application of artificial intelligence in court systems. As a member of the committee, I know it has not completely, we have not given the recommendations yet. We are still at a very preliminary stage. But one thing which has happened is we have at least been able to broadly identify the areas where artificial intelligence can work. And the Chief Justice at that time, Justice Gogoi, was to remind us all that artificial intelligence will not substitute the judge's intelligence or the lawyer's intelligence. The same way, our present Chief Justice of India has also gone on record in public platforms saying artificial intelligence cannot substitute or supplant the human intelligence. What are we now trying to talk about when we're talking about artificial intelligence? We are trying to see how this artificial intelligence can assist the court process in the adjudication. What are those things which need not come through court? It can be, you can have some formulations, you can have some kind of modules prepared where the artificial intelligence can be applied to see in a given set of facts, or this is the law, to match them and then see a particular answer, give an answer quickly. so that there is a judge who overlooks everything, and there is a lawyer who sees that all data, what is necessary, is given there, and a decision can be taken. So therefore, the artificial intelligence of what we are talking about has at least 4 immediate areas of activity, which is now under consideration. One is translations, which are already rolled out. Still, of course, is in the process of its kind of a pilot yet. If you go to Supreme Court website now, of any judgment which is given there, on the right side, translations, there is a block for you. It's possible for you to go in there, and it's possible for you to secure a translation in probably in Tamil, in Bengali, in Urdu. Even Urdu has been now added. So therefore, you have immediately translations available. These are not word-for-word translations. It's sentence-wise. Several attempts have been made. It has been done through with the assistance of truly knowledgeable people. So therefore, the translations, you go and try them. If there is anything wrong, you can check it up, and the machine learns that the next time it will translate more appropriately. So therefore, that is one area where in artificial intelligence we have done something. And data assimilation, collection of a large volume of data. You would have noticed probably if you have gone to the High Court and the Supreme Court, how the typeset are drawn with some 2,000 pages, 3,000 pages. Or in Babri Ram Janmabhoomi case, where you had volumes which had to be brought through probably a few truckloads had arrived. So all these are digitized. And first of all, for digitization, it has to be in computer legible language. You can't simply take everything as scribble and then say the computer understands. It doesn't. It has to be computer legible. It's a particular format, how it is to be done. And that from that data, how you can, what kind of questions can go? For instance, if it's a criminal trial, who is the eyewitness to this? Where do you find the corroboration? What are the weapons which are used? And how do you relate this particular weapon to this type of injury? As an argument is made when the judge poses the questions, you will find in court, lawyer, if he has full preparation and everything jotted down, he'll be able to answer. Probably in his own narration as he progresses in the case, he'll be able to give every detail. But then as and when the judge poses a question, if he runs through and rummages through the pages and then it takes some time. Now, it's not in the way this artificial intelligence is now conceived and they're thinking of implementation. Volume of data will be collected, they're all fed into the computer. You ask the question because as a pilot project, they took it up from Jharkhand. They had somewhere close to about some 150 questions. So therefore, these questions, it will immediately take you to page 742, para 2, the line 4. You have an answer. Who is the eyewitness? That eyewitness corroboration, where do you have? These are the witnesses who have corroborated there. Which page you want, you immediately have it. So therefore, it will facilitate quicker access to information of what a judge looks to. Quicker information for what the lawyer would require to know in order that he presents the case. That is another area where artificial intelligence can work in a big way. It will come through probably in course of time. And again, enabling predictions. This is what in a recent book which a Harvard professor has written, Susskind, he says it will give predictions. It's possible for you to assign some cases. What is this? This is how cases have been decided. We understand very easily a system of precedent is to make possible a consistency in approach. You have a given set of facts. They give rise to some problems, and this is what the courts have said. This is how the law is applied. So therefore, you have the system of precedents which help you understand how in a given situation, previously this court has decided, which the Supreme Court has decided. The same way it is possible for you to also find out what will be the outcome. But that could be, again, probably a very dangerous thing. In fact, this was discussed in one of our meetings, and it was said that if only you look for this kind of predictions, then it will be dangerous. Suppose the judge takes a view which is not, which according to him was to be dealt in a particular way, because there are so many issues of discretion. Everything is not merely to be understood in terms of binary options of what is right and what is wrong. It doesn't go like that. There is some way, it's not at all times the right and wrong which matters. What is just in a particular situation? Machines can't work there. So now to look for predictions, and then if a judge gives a ruling and then somebody comes up with saying the prediction elsewhere through the artificial intelligence is something, how come you have given a judgment like this? That could be dangerous. Therefore, Susskind says in that book that at least in some areas where there is so much of written data, calculations and things, it's possible for you to adopt these modules and give also options to persons whether they'll go for a predictive mode or what you would like to take a decision through a computer system and through artificial intelligence, whether you would abide by that. There should be a previously an information acceptance given, it could be done. This is some suggestion from an academic. I'm not saying this is immediately considered, but I'm only saying that it is possible in artificial intelligence. It can also give rise to some, it can give you a percentage of predictions of a particular time of phase of success. And in my view, and in the view of some of the persons who are associated with me in the committee, there are surely areas where artificial intelligence can work very effectively, and the courts to oversee and how it happens. In all matters relating to determination of compensation, for instance, motor accident claims for compensation. Day before yesterday, when a new platform was opened from Delhi at the Madras High Court, because it's somewhere close to me, and therefore I'm saying, I'm sure it's happening elsewhere in some of the states as well, in some other high courts as well, where all traffic challans and things, it will not go through any trial. It will immediately say, it will also capture a photograph for you if you have crossed the zebra line, you did not stop by the red light, and then immediately the police stops you, it challans you, and then gives you an information about what is the fine which will become payable, or what could be the outer limit. Or you may set a date. You can go there, a person can log in and wants to pay the money, it can be paid. The fine can be paid by online transaction and transfers. And it can also, if somebody wants to contest, he can call for evidence, he can seek for evidence, and then have a real trial taking place. So this is another area where it can open. And that is where they've said it is possible for you to have virtual courts. But artificial intelligence comes with a slightly different thing, or it can help you gather all data. Particularly in that yesterday's meeting, they were also said, even for determination of compensation, motor accident claims, artificial intelligence is used. And it is the stage of preparation. I'm sure it will be put through a pilot project soon, and we will know. Similarly, other areas of compensation, like land acquisition, where you have large data which is available there at the registered offices. Registration offices will be able to tell you what is the circle value in the particular place. So therefore, values all assimilated properly, and then what will be the compensation given? It will not hand out the compensation. It will be brought before a court where the judge will see whether everything is done properly, whether all the relevant details are there, have they been accepted. The machine will learn even that aspect of how it has been ultimately decided. It will go into the system for it to improve in the next stage. So this is how I am able to see artificial intelligence can assist the adjudication, and the way the virtual courts open. I told you more about the limitations of the virtual courts, where it can work and where it cannot. So this is how I largely see these two applications in these areas.
Okay. So as you are the pioneer in the area of mediation in the country, how the ADR in general and mediation in particular can help us in speedy disposal of cases?
Yeah, that is too big an identification for me as a pioneer in mediation. Perhaps I'm one of those several persons who are passionately involved in mediation. There are any number of other persons. Sriram is one, Karachiwala another, Niranjan Bhatt another, and there are judges who are so actively associated and who have improved the cause. And so therefore, there are ever so many persons who are involved. I have also an interest, and that's why I've started an independent area of work which has to be done. Now, how do I see this? One thing, truth be told, that when we are talking about thousands, lakhs and crores of cases, when we are talking about mediation, we are not talking about crores or lakhs or even thousands. We are talking in terms of some hundreds in each court. So therefore, in terms of the number of what we are taking for mediation, it's not very big. But it has immense potential. If in US today, 85% of cases are settled at mediation or after the case is brought to court and before court, even pre-litigation. It is because they have the one thing which pushed them to that, like what I said, from how Pound started to how Chief Justice Berger thought it was essential for all court systems to adopt. Mediation comes with an enormous value that my dispute, I understand better. As a litigant, I know my case better. I would like to believe that I know better than what your judge knows. Why will I cede that authority to another person to judge my case? Why will I not sit with the other person with whom I have a dispute? And if there is a person who can help me identify a conversation to take effectively, why will I not utilize the services and secure to myself a solution? So therefore, I think the power to the litigants themselves to decide and come to what will work for me without getting bogged down what is right and wrong, what is appropriate to another person. That the power resides in me to decide of how I would want my problem to be navigated is very important. So therefore, mediation, I would think, is a great scope in all matters relating to commercial disputes, where for a businessman, time is money. And if he's going to be wasting his time in court, I told you about the kind of statistics, between 5 to 10%, from 5 years to 10 years, 15% of cases out of 3.2 millions are the kind of time which the take. And why should any person who has a business to handle, which is to make it work, be wasting his time in court? And that if only you provide to them an immediate mechanism to address the problems, it will work in a big way. And that is the reason why you have a Commercial Courts Act which mandates mediation, which requires the parties to try the work first before a mediator. It has some limitations. It looks to only the legal services authority to be the service provider. It should open up in a big way. It has not happened. So therefore, it's not becoming popular yet. It is not popular because it is in the hands of MCPC driven, that is a mediation and conciliation project committee driven legal services authority, which offers the services for commercial mediation. You open the door for private mediation in a big way, it should probably work. 31 legislation, Professor Ahmad, where the central legislation, you have references to mediation. You therefore imagine that there is so much of concern that the legislative exercise has been such that parties are directed to go to mediation before they come to court. Or if they are in court, that they must try out mediation. You have in the Companies Act a provision for mediation. You have in the Sarfasi Act, the Securitization Act, where there is a provision for mediation in Section 11. Therefore, many of the cases of what can go through the insolvency professionals at the time when a company is not doing well and it has gone to the company law tribunal, NCLT, there is a provision there in order that all disputes are sorted out. There is immediately available a mediation panel, which is a mediation and conciliation panel of what is there available under the NCLT. Under the provisions of the Companies Act, there is a scope for you to go for mediation. So enormous legislations are there, and but they're not. We are not putting them all to best of use. Why is it not done? There are two reasons which I would say. One, there is a greater need for understanding that mediation works and it can be very effective. It is not an abdication of authority or power by the court or inability to cope with things, therefore they are consigning something to mediation. It ought not to be seen as merely an apology for non-performance or our inability to dispose of cases. On the other hand, mediation must be strengthened for its own cause of how it is important for people to see that there is a scheme which is available and where you can go and discuss, where conversations are possible. I can explain to a mediator what drives me to say what I'm saying, what puts me to do what I'm doing. These are all essential things to identify an underlying interest for a particular conflict. The courts just don't have the time or resource to do that. If a case comes, and then I say a landlord in a particular COVID situation, landlord is not being paid rent, the tenant is not able to pay the rent. And you go to the court and it will say now, yes, but there has been a willful default in payment of rent, or there is a default, is it willful or not? COVID, can it be a justification or not? These are matters which will be taken on the evidence which is given and stated. But then you go to a mediator, probably he'll be able to tell you, why are you not able to pay? How long do you think you'll be able to take? These kind of questions can be asked. You can unravel a problem minutely. You can divide a large set of facts into subsets and then try to find through each one of them what really is the reason why there is a conflict. So this approach will work great wonders, and that's what should happen. So all over the world, that is the process, because it is enduring. Whenever we are talking about a court system, I have a case decided. There is a subordinate judge who has disposed of the case. There is a case is not disposed of. It is merely disposed of from that court. It gets displaced to another forum. You have all the judicial ties. Have you not heard about litigants saying, I'll take you up to the Supreme Court? Therefore, when we're talking about the mediation, you don't take you to any other place. You have gone there to the mediation. The case is taken, finished, taken off the grid. That is what we are seeing. So therefore, that empowerment of what happens through mediation and a finality to what obtains ultimately in the manner in which a problem is addressed and a resolution obtained, I think it's enormous. So I think mediation offers great scope. But then what is lacking? Now, apart from some reluctance of people, of judges who don't appropriate referrals, or probably in situations where you don't have the themselves willing, because it comes with whole new skill sets. What you do in court is arguing for a particular thing. What you go in a mediation is negotiating for your rights. So skills of negotiation are something which are very relevant, very important. Everyone, of course, because I'm addressing some of the students, you shouldn't be thinking, what am I going to be doing in mediation if the MCPC rules, the Mediation and Conciliation Project Committee rule requires a person to be 10 years in practice at least before he becomes a mediator. How is it going to work? How are you going to secure the benefit of mediation? In mediation, you just don't argue and take adversarial positions as you do in court. In court, at all times, your focus is trying to pick holes on the other side. In mediation, I would be looking at what is my strength, what is her strength, what is the way to take forward. Why would I want this? How will I make the person understand this is what I would require in order that the case is settled? So therefore, I look for it's bargaining for positions, securing what is your interest is, and then heading towards a kind of a solution which will work for both. Negotiation is a big art. A lot of schools, law schools outside India are going a big way. And I know also probably university also offers some courses for negotiation. Business in the Harvard Business School has negotiation as a very important area. Also, I know Stanford and all big universities in UK, in Australia. In all these places, negotiation is taking big ground because lawyers obtain the new skills of negotiation. And that is where you can really make it work better. So I would like to believe that mediation, if it is there, we require all these things done, and we require a standalone legislation. That is perhaps lacking now, and that is the reason you also made at the time when you were making a reference about me, about my committee for formation of mediation law. This just this way. This has come through a judgment, an order of the Supreme Court, where it has seen some serious legislative deficit. While so many legislation talk about mediation and the need for mediation, we don't have a mediation law fully and exclusive as a standalone legislation. Recently, in the year 2019 in August, India was a signatory to a convention for mediation, international cross-border mediation, to be recognized and to be enforced as if it were a decree or a judgment. And when will that happen? It requires, it expects all the countries to have domestic law to make possible any mediation which takes place elsewhere, enforced in our own country. So therefore, the standalone legislation has not yet happened, and I hope it should happen. If it does not happen, like in Visakhapatnam guidelines, till a legislative exercise is undertaken and then it is done, the Supreme Court itself could be framing something and coming. The MCPC is does not address all issues, and therefore, through a committee constituted by the Supreme Court, we are looking for various things, trying to make a law and then present it to Supreme Court. Supreme Court will probably take it as a pilot and see how they can be done till a legislation comes. So therefore, the parliamentary exercise of framing a law cannot be usurped or taken away by some other persons, like a committee persons like me, but that will be done elsewhere. But this is for us to identify how this law, persons who understand this mediation, how this law can work better. What are all the provisions which could be there? So it is all at the stage of discussion yet. It has not taken any final shape. And the relevance of mediation is and how important it is what I attempted to tell you.
Okay. So please tell us the impact of artificial intelligence and virtual courts on future employment of law professionals and how they can meet the skill gaps.
Yeah. Right now, if I was telling you about artificial intelligence or virtual courts, I was telling you about the inherent limitations of what they have. In artificial intelligence, you don't really substitute a human intelligence. In virtual courts, you don't really make possible easy transmission of all documents and things. And the physical courts are absolutely essential. But they come with different skills. For artificial intelligence now, you're not going to be writing codes. You're not going to be writing the programs yourself. What a lawyer who would be using artificial intelligence is the gathering of data is what is probably the volume of data, what is necessary. Any of our present generation of people, they understand computers much better than what I've done. So I still look to my son before I speak somewhere, before I need to have some presentation, I put it through my son. It's obvious reason is that the next generation understands it better. So I would, there is a skill gap of what you're saying. It does exist, because in our law schools, we don't go beyond teaching them law. Of course, for persons, there are ever so many subjects that you have. For a person who is trained in law, must not ever say, sir, I've not understood all this. There is nothing like not understanding things. You need to understand. And it is all not going to be your performance in courts. Performance in courts and arguing cannot be there, because they're already saying today somebody writes in a leading newspaper as to how big reforms must come. Among other things, it's a law firm which writes and says that we need to curtail our own time in courts. Many cases probably will be decided in future, not on arguments, it could be on written submissions. Writing crisply. So therefore, when you are talking about digitization, the volumes of what we are used to, from there, how do we compress a lot of volume? How do I understand technology which can secure the transfer of information from me to the other person as quickly as communication technology? So these are things which our children know, themselves, they get exposed even very early in schools, even before they come to colleges. But then how they're all applied in the manner of preparation of your pleadings to collection of evidence. There is also for discovery and inspection, there is artificial intelligence which is used. There are private companies. In fact, I know of an American company, Everlaw. Their tagline is "Don't settle, litigate." So therefore, when we are talking about settle, don't litigate, there is in discovery and inspection, they're talking about how to generate questions, how to find out, dig out facts for you. All that artificial intelligence picks up. So therefore, give all data, it will do. So what are all the applications which are possible through artificial intelligence? It's time for all these students to know what kind of applications are possible for my court practice. How do I gather data? What if this data, what will artificial intelligence enable me to secure? You need to know that. And when you're talking about virtual courts, be used to prepare everything, not in a position to think that you can give it to the judge or show in photograph. The judge may say, no, look at that, and say, no, it's not, I'm not able to see. Please file a copy. Then you'll have to take another time, send it. So the speed, which is essential, because that is where we seem to be lagging behind. We need speed. Courts are very slow in the way they function. And we need our ability to dispose of more. We have large number of accumulations, and that all these things virtual courts can help. And artificial intelligence, I'm sure in certain areas, it'll where it's mere automation and it's not too much of your discretion which is in application, which is to be applied. And that's a huge scope for artificial intelligence for persons to be using. So therefore, identify areas. Right now, they're already trying to do in some physical calculations and things where predictability is more in certain types of cases. We will identify those things. And that is the learning which probably students of law must do. Try to know about artificial intelligence. Try and see what are all the methods of digitization, how it can work in courts. How do you improve skills of communication through feel comfortable about communication in digital ways. And that is important because at some point of time, I used to know my father would say that book at page 432, the the last paragraph, you have the end note. In that end note, you have the third note. I would have marked there. That kind of remembrance is probably of another generation. Our things, we don't require that kind of memory at all. All that is available in your pad, all that is available in your personal computer. So therefore, we will probably use our intelligence elsewhere. It is not as if we are not going to use any skill of memory. It is essential. You can store a lot of things through computers, and therefore your ability can be in something else. Your probably ability to put things very concisely. Has it not happened in your experience that the generation next finds very few words to say to express large things than persons of my generation? We probably require longer time to explain things, but the next generation understands and then says things very quickly. So therefore, writing precisely, brevity is an expression of how we can do. These are all the new skills which you learn. And I'm sure with virtual courts, which is a certainty, as we have already seen its introduction in some places because of COVID, and some of them can be retained even post-COVID. And artificial intelligence, or what I say, of how it's likely to get integrated slowly and slowly. It has already happened in one area of accumulation of gathering data and then trying to find answers immediately through artificial intelligence. It'll all come to courts. They're not going to take any work away from a lawyer. It'll, on the other hand, provide an immediate method of accessing information and securing results. So therefore, great scope. A lot more work is possible through lawyers, where we are taking, if it's taking 10 years to do a case and that the file is merely accumulating, probably you'll do it in less than a year's time. You have new cases coming and occupying your shelves. So therefore, that is what brings more litigation. I see no scope for no litigation situation. There are bound to be litigations so long as there are human interactions. And human interactions are more these days with better enabled communication technologies. So that's how I see the work happening.
Thank you, sir. You are part of the drafting committee of the mediation that law is coming into force. When we can expect the law, and what is your personal thoughts about the mediation law in the country?
Yeah, mediation law, we have come through several small hiccups. Mediation law must come. Actually, if India has been a signatory to Singapore Convention, it is expected to give effect to those cross-border mediations. It will work, and that, of course, Singapore Convention addresses only commercial litigations. It does not talk about. It makes an express exclusion of succession laws or matrimonial matters, which is a large area of practice through mediation. So therefore, we, for large number of areas, the Singapore Convention itself will not apply. But then we all understand how important separate law is. And right now, it's merely at the stage of deliberations. I would expect the Parliament itself to state that they have several drafts available. We'll probably be able to finalize something quickly and then put it in the court, and Supreme Court will probably give. I think another 3-4 months time is good enough, and we may have an independent law. Right now, we have Arbitration Conciliation Act. Conciliation, the word conciliation is a process of mediation. It's an understanding of mediation is possible through conciliation as well. It's only a process which is different, where the act contemplates a proactive approaches by the person who is a conciliator. In mediation, it will be a complete neutral, non-interventionist approach. Basically, though there could be in certain types of mediation, where there can be some forceful suggestions also from mediators. So this law right now, there have been no recommendations by the committee yet. And the law, when it takes effect, it will bring the best practices of what obtains across the world. And I'm sure the Supreme Court overlooking what we are going to be giving to them, we'll have the best of draft of legislation. And I'm sure the Parliament, when it takes up, it will have also the benefit of experts in the area of mediation who have put together some kind of a draft. Normally, the experts also, the opinions are taken at the stage of drafting. It can go through the parliamentary special committees or through the ministries. They also invariably elicit information, fine-tune before it is taken to the Parliament for approval of the bill. Now, it can go through that kind of exercise. And we have our draft can also be an additional resource for the Parliament when it takes up legislation in its anvil. So this is my statement on mediation law now.
Thank you, Lordship, for very nicely presenting your views on various aspects of AI, mediation, and ADR, and also disposal of cases. We are really honored and enriched by your great thoughts. We are lucky that you found time from busy schedule and address today. Sir, thank you very much for your valuable thoughts and also finding time. We'll look forward that please come to our campus when the lockdown opens and address to our student faculty. Thank you very much for today's deliberation and very enriched lecture. Thank you.
Thank you, Dr. Ahmad. It's my pleasure to be associated with your university and your students. I'm sure there'll be some occasions when we can come and meet at your campus, and when we can share our experiences. Thank you very much.
Okay. Thank you.